I'm not a professional speaker or presenter. I'm just someone trying to deliver you information. What you do with this information is up to you. I'm also not advocating any kind of violence. Every problem in the world can be solved by who you see when you look into the mirror. And this is not to be construed to be as legal advice of any kind. I put this presentation together so I could show the people of this great country a true and accurate view of history about what happened to our country. The facts I'm going to show you are not Republican or Democratic in nature. There are documents from the Library of Congress, state archives, Supreme Court, Senate, and congressional records and reports. Anyone can go get a certified copy of any of these documents for your own research. What I'm going to show you is a small but important part of what has delivered this country into its current condition. I kindly ask you, do not believe what I'm going to show you. Please do your own research and the truth will be yours. One of the reasons we are in the shape we are in as a country is because we let others tell us what the facts are. The story I'm going to tell you is about a corporate takeover that history forgot to tell you about. J. Edgar Hoover said, "The individual is handicapped by coming face to face with a conspiracy so monstrous that people cannot believe that it even exists." I promise you this conspiracy exists. So some things we're going to talk about today is, why did we fight the Civil War? What was the purpose? Was it to free or create slaves? And how does it affect our personal and property rights today? Facts about the South seceding from the Union. Slavery was not an issue, it was states' rights. Lincoln even told President Davis that slavery would be intact if they came back into the Union. Davis' response was, no, because slavery is not the struggle we fight in this war. 4 states that fought with the North were slave states throughout the war. President Buchanan did not wage war on the seceded states. All these states succeeded while he was in office. On February 28, 1861, North Carolina legislators voted on whether they wanted a convention to consider secession. The call for a convention was defeated by 651 votes. North Carolina would not even consider secession. On March 30, 1861, in an address to the people of Texas, put forth by representatives of Texas, given warning that under the pretense of freeing slaves, the actual intention of the incoming Lincoln administration was to enslave a whole nation. An ominous warning of what was to come. So why did North Carolina secede from the Union? On April 15, 1861, the Secretary of War notified Governor Ellis of North Carolina that the federal government expected North Carolina to furnish 2 regiments of troops to make war on seceded states. In Governor Ellis's refusal, he closed with these words, "I can be no party to this wicked violation of the laws of this country. Into this war upon liberties of a free people. You can get no troops from North Carolina." And North Carolina seceded from the Union. This document is known as the Lieber Code or General Orders 100, done April 24, 1863. It is the rules of engagement signed by the Secretary of War for the Civil War. We are still operating underneath these rules, underneath military rule. Here are a few of the articles that affect us today. Martial law in a hostile country consists in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government in the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation of general laws as far as military necessity requires the suspension, substitution, or dictation. So what this Article 3 is saying is we're going to suspend all of your laws while you're underneath military rule. Article 7. Martial law extends to property and to persons, whether they are subjects of the enemy or aliens to that government or not. Basically, they're saying right there, it doesn't matter if you were against us in the war in the South or whatever the deal was, the martial law is going to extend to your property and to the person, whether they were enemies or not. And that's pretty simple. That's how this affects the North also. Article 26. Commanding generals may cause the magistrates and civil officers of the hostile country to take an oath of temporary allegiance or an oath of fidelity to their own victorious government or rulers, and they may expel everyone who declines to do so. Article 31. A victorious army appropriates or seizes all public money, seizes all public movable property until further direction by its government, and sequesters for its own benefit or that of its government all revenues of real property belonging to the hostile government or nation. Title to such real property remains in abeyance or suspended during military occupation, and until the conquest is made complete. And the last one we're going to talk about is Article 32. The commander of the army must leave it to the ultimate treaty of peace to settle the permanency of this change. There has never been a treaty of peace ending the Civil War, and we're still under these rules. You own no property. Article 31 still applies to you today. Article 26 that we're going to talk about shows where they forced several governors and legislators out of office 3 years after the war was over because they didn't want to go underneath military rule. They wanted to stay underneath constitutional rule where the states were the sovereign. This document is from the nps.gov website, National Park Service. And the question here is, where was the treaty signed? And they're talking about the Treaty of Peace to ending the Civil War. And their answer is, there was no treaty signed to end the Civil War. This document is titled Contracts Payable in Gold, known as Senate Report 43 or Senate Resolution 62. It was done in 1933, 60 years after the Lieber Code or General Orders 100 was written. The discussion on the floor here is we have three types of money: paper that represents gold, gold and silver, the actual physical substance, and we have fiat currency, which is worthless paper, which we use today. The comment here is that I have highlighted in yellow. It says the ultimate ownership of all property is in the state. Individual so-called ownership is only by virtue of government, i.e. law, amounting to mere user, and must be in accordance with the law and subordinate to the necessities of the state. If you look at your deed, it says you're a tenant. Look up the definition of what a tenant is. You're a renter. So basically what happened, or what this proves, one of the ways, is that you own no property. You pay mortgages on property that you own. You pay property taxes on property that you don't own. Your car you don't own. You own nothing. And when they say the ultimate ownership of all properties in the state, they mean that. That's how they can seize your property anytime they want to. It's really theirs and you're just using it. Fourth Amendment of the Constitution, ratified in 1791, says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. Clearly, they took everybody's property in 1863, and this includes the North, the population of the North, and they did not notify anybody that this happened. They're very patient. So everything was settled after the war, right? What happened? In 1865, North Carolina was admitted back into the Union as the 12th state. December 4th, 1865, North Carolina even ratified a new 13th Amendment, proving the state was back into the Union. The old 13th Amendment, that was ratified in 1819, was removed from the history books in the Constitution, unlawfully of course. It said, if any citizen of the United States shall accept, claim, receive, or retain any title of nobility or honor, such person shall cease to be a citizen of the United States and shall be incapable of holding any office or trust, profit under them or either of them. An example here is Esquire. Let's look at the original archive certified copy of the 13th Amendment. This came from the Texas State Library in 2009. And this is actually a certified copy of Virginia's Constitution along with the Constitution of the United States. And on this page right here you can see Article 13, which says exactly what I just read you. So, let's look at what an esquire is, which is an attorney. Bouvier's Law Dictionary, 1856. Esquire, a title applied by courtesy to officers of almost every description, to members of the bar, and to others. Okay? It is a title next above that of a gentleman and below a knight. Now, most of you don't really understand this because we just weren't taught it properly in school, but there are no titles in this country because everybody was a king. That's what a sovereign is. We were kings on the land. Only law could rule man, not man. That's why our Constitution, our founding fathers set up our Constitution, set up a republic. Let's go down here to 4. Esquires, by virtue of their office as justices of the peace and others who bear an office of trust under the crown. Now, you guys, I'm just going to go into this a little bit. You're going to need to do your own research and see why are we still under the crown. I'll show you some evidence of that, but really, this alone could take a week. But just understand, an attorney, whether they know it or not, having the title Esquire is an agent for the crown. But North Carolina, along with other states, refused to ratify the 14th Amendment. Why? That's the one that says we're all U.S. citizens. What's wrong with that? March 2nd, 1867. Faced with ratification failure, Congress passed over President Johnson's vetoes 3 Reconstruction Acts from March 2nd, 1867 to July 19th, 1867, declaring the southern state governments to be illegal. Following are excerpts from President Johnson's veto message to Congress regarding its first Reconstruction Act. The military is being used to coerce the people into adopting principles and measures that they are opposed to, in which they have an undeniable right to exercise their own judgment. The bill is without precedent and without authority, in palpable conflict with the Constitution, and utterly destructive to those principles of liberty and humanity for which our ancestors on both sides of the Atlantic have shed so much blood and expended so much treasure. The purpose and object of this bill is to change the entire structure and character of the states' governments, and to compel them by force to the adoption of organic laws and regulations, which they are unwilling to accept if left to themselves. If they do not form a constitution with prescribed articles in it, and afterwards elect a legislature which will act upon certain measures in a prescribed way through subjugation, neither blacks nor whites can be relieved from the slavery which the bill imposes upon them. So what President Johnson is telling you, that this 14th Amendment bill was going to make both blacks and whites slaves. Pretty strong language. What other evidence do we have of that? So the constitutionality of the 14th Amendment and the Reconstruction Acts went before the Supreme Court on 4 different occasions. First time, the court dismissed on technical ground that the court had no jurisdiction of a bill to enjoin the president in the performance of his duties. They couldn't make him do his job. Second time, the court declined jurisdiction by holding that the case concerned purely political matters instead of personal and property rights, which at one time was the only way you could get a case in front of a court if there was an injured party, a real injured party, and there was that gave him standing. The court held that a bill to restrain the defendants who represent the executive authority of government from carrying into execution certain acts of Congress, inasmuch as such execution would annul and totally abolish the existing state governments of Georgia, is not within the jurisdiction of the court. In other words, the court said it could not stop the federal government from completely annihilating or abolishing the state of Georgia. And that's exactly what happened. It abolished every state. The third time, the Supreme Court assumed jurisdiction on the constitutionality of the Reconstruction Acts, and were argued before the Supreme Court. But before the Supreme Court could enter a judgment, the Republicans in control of Congress rushed through a bill repealing the appellate jurisdiction of the Supreme Court under the Act of 1867, prohibiting the Supreme Court from proceeding on any appeal already before it. The court waited till the bill was passed and then postponed for further consideration of the matter until the next term. In the biggest battle between Congress and the Supreme Court in the nation's history, for the first time, Congress removed the court's jurisdiction to hear a case. The last attempt to obtain a ruling on the Reconstruction Acts was made in Ex parte versus Yeager. The Supreme Court assumed jurisdiction, and this action was immediately answered by the introduction of a bill in the Senate explicitly prohibiting the Supreme Court from considering any case which involved the validity of the Reconstruction Acts, followed by another prohibiting the judicial review of any act of Congress. Congress made themselves, in the laws and bills they passed, untouchable. So much for the 3 equal-powered branches of government. The Tulane Law Review, Volume 28 of 1953, an article entitled The Dubious Origin of the 14th Amendment, by Walter J. Sutton, Jr., former president of Louisiana State Bar, states, "The most extreme and amazing feature of the Act, as the requirement that each excluded state must ratify the 14th Amendment in order to again enjoy the status and rights of a state, including representation in Congress. Section 3 of the Act sets forth this compulsive coercion that's imposed on southern states. The most apt characterization of this compulsive provision, placing these states under military authority, there to remain until they comply, inter alia, with this requirement of ratifying the rejected 14th Amendment, is found in a speech of Senator Doolittle of Wisconsin, a Northerner, a conservative Republican. During the floor debate on the bill, he said, 'My friend has said, what has been said all around me, and what is said every day, the people of the South have rejected the constitutional amendment, and therefore we will march upon them and force them to adopt it at the point of a bayonet, and establish military rule over them until they do adopt it.'" And you can see the source there. So obviously, our founding fathers, which the Constitution guarantees every state the right of republic, the right to have a republic. Our founding fathers never thought that they were going to get the states to ratify something at the point of a bayonet. That's not their intention. So what has Congress said about the 14th Amendment? On June 13th, 1967, United States Representative Rarick of Louisiana submitted to the United States Congress Louisiana House concurrent resolution urging the United States Congress to declare the 14th Amendment to be illegal. He also entered a treatise on the illegality of the 14th Amendment prepared by Louisiana Judge Lander H. Perez. You see, you guys, attorneys and judges have tried to help us. We have failed to support them. Congressional Record, 1960.